Hello, it's Phillip Taylor from Richmond Green Chambers. I'm talking about a book by Colin Sara called Boundaries and Easements. It's an interesting area of English land law, and one which certainly students have always found interesting after the dullness of the law of property legislation. What I've actually titled this review, and there's a written review on the internet, I've entitled it Easing the Tense Boundaries of the Law, because clearly the issue of neighbour disputes is one of the biggest single areas that builds up in the Crown Court, in the county courts in particular, but sometimes in the Crown Courts, into legal action. Obviously there's a massive amount of civil action, but there's sometimes a criminal element too, because obviously people just cannot get on. This is about the civil areas of law, and what Mr. Sara has done is he's actually given an excellent exposition of the law relating to boundaries, to disputes, and the current concepts we have about the law relating to easements. It deals with the frustrations of the subject, which I share, and that they actually came out in his preface, where he talked about long judgments that we have, and the issue of unfixed boundaries, and the procrastinations of the Law Commission. Now, obviously, boundary rows are the bread and butter of many a county court case. I've actually always enjoyed teaching this subject because it's an area where you've got the human interest value in an otherwise boring subject. Now, the fourth edition gives us, as both practitioners and as trainees, all the material we require to conduct an action involving easement claims or boundary disputes with neighbours, which obviously can be lumped together because of the right that's vested in the property. What I liked about the way that Sara tackles his project and compiled this book was his belated acknowledgement that older precedents and the historic basis of easements, using clarity from many of the 19th century judgments, are, and he actually comments on it, important, even though he tends to use what he calls more modern pronouncements of the law, and he has the habit here of giving up chapter headings to help the structure of the judgments as they're reported, and that I think is quite a useful thing for anybody looking at a book on easements. He's achieved a nice balance as a result with the older and the newer cases as they've come along. There are 6 parts to the book: boundaries, easements, remedies, precedents, statutes and statutory instruments. So it's a detailed, heavy work. And the first 3 parts make up the meat of the subject, with 24 chapters in all, covering everything that's relevant to us as practitioners. There are, in the later parts, heavy detail on how to mount successful actions in this area, which will be of great use, certainly initially for solicitors, but then again for counsel as we present the case in court. Now, as I've said, neighbour disputes are the biggest single issue that we face in many civil actions. And what Colin Sara says is this: he writes that he has more of a sense of apprehension than joy when the client greets him with the words, "I've got a boundary dispute." A bit like the massive number of neighbour disputes which adorn the law of tort today and give the law its human face. And of course that's, as I said earlier, very much a positive factor with this book. It's a bit like saying, "I want my day in court," of course, and you know immediately as an advocate that your heart will probably sink a bit when you hear them say that. When I first taught land law, which is actually 20 odd years ago now, the biggest turn-off for the learner at that time was the legislation itself. So what you've got here is some nice, useful examples from the case law. Obviously it's also very relevant for people studying to look at the actual comments that Sara has made, because he brings actually over 35 years of practice to this subject. It's something that is of great benefit to everybody concerned. I think the secret to enjoying the subject as well, especially easements, is the attractiveness, because it's one of the least boring areas of law. It's entertaining to a certain extent. If, as I do, you have to step away from it and look at what's happened and see just how one can try and sort out the mess that people get themselves into. All the easement suspects are mentioned, from Wealden and Burrows to the 1832 Prescription Act, with its quaint English, and of course that old lovely old area, the Lost Modern Grant. He puts it beautifully when he says, "It's not a rebuttable presumption, but a fiction." And the law doesn't tell lies. Haha. Well, the thing is that we all know about it, and I mean, where would we be otherwise? You've got to try and create something that will give the law some stability. Now, as I've said, the boundary claims that are dealt with often unfold the history, as he puts it, of a tiny corner of the country over a period of, say, up to 100 years, moving from visits by the vicar on horseback through carrying water from the well up to the arrival of combine harvesters and the satellite dish delivery. Now, you've got a wonderful picture there of how England itself has changed, and obviously the law has got to change with it. I think the imagery is great, and of course, as I say, the book itself is good, in that it covers a very large amount of the very practical information we need, but there is the heavy element too, to give it the authority. The book is primarily aimed, of course, at the practitioner, and I think that in itself is good. It's good, of course, for the academic. It's a one-stop shop, and I say that about a lot of books, because obviously you haven't got the loose leaf element of it. It's a proper book, but it gives you all the points of law and procedure you need. Obviously, costs can quite often far exceed the value of any claim, but Sara makes the point to feel pessimistic about whether we will ever get all these titles that we need to have to property registered. I'm sure it will happen. It's just taken a lot longer than we had thought. I can't help but feel, however, that if we can't do this with the brilliant technology we currently have, when will we ever get it done? And that, of course, is the big question. I think it's got to be a little bit of prodding to get it going. Anyway, thank you, Mr. Sara, for a great new edition, which I'm going to use again and again. Thanks a lot. Bye-bye.